All right. Good afternoon, everyone. Thanks so much for tuning into today's event. My name is Rachel Rossi. I am the president of Alliance for Justice, an association of nonprofit member organizations committed to building power, transforming courts, and securing justice for all. And as many know, AFJ brings technical and content expertise, a deep reach in movement advocacy and legal networks, and trusted decades-long experience in our work to transform the courts. What we've seen since the recent election has only underscored the critical nature of AFJ's mission, highlighting the urgent need for a fair and impartial court system. Today's conversation is part of our ongoing series, Holding Court, Justice Conversations with AFJ. And this series features leading activists, authors, scholars, and attorneys discussing current political and social justice issues. And today we are in for a treat. Joining us for Holding Court, the Supreme Court, and Conservative Grievance is Leah Litman. Leah is a professor of law at the University of Michigan. She is a former Supreme Court clerk. Also, many of you, I'm sure, know Leah as the co-host of the very popular podcast, Strict Scrutiny. She also writes frequently about the Supreme Court and has appeared as a commentator on various media outlets. Leah has also received the Ruth Bader Ginsburg Award for her scholarly excellence from the American Constitution Society, and she has been published in top law reviews. But today, Leah is joining us to discuss her recently published book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Leah, thanks so much for joining us.
Thanks so much for having me.
And for our audience, later in the discussion, there will be an opportunity for you to ask questions. So please submit your questions in the comment box on the platform where you are watching. Please note that AFJ staff members will be monitoring the comments, and any comments that are not in line with our mission or are discriminatory could be deleted. All right, let's get started. And first, Leah, congratulations on publishing Lawless. I know the book was just released, was it 2 weeks ago?
Yes, so May 13th was the publication date.
Fantastic. And for those who are listening and watching, if you haven't gotten it yet, make sure to stop by your bookstore and get a copy of the book. And just to kick things off, Leah, I'd love to hear a little bit about just the style, the intended audience of the book. I'm brand new to AFJ, but one of the things I inherited was an entire history of Supreme Court books. And I just have to say, yours is quite different. Can you tell us about your style?
Yes, so the style is intended to be different than your average Supreme Court tome, and is different both in content and style. So stylistically, I wanted to write it in a conversational tone that was also a little snarky and irreverent. I think sometimes people take the Supreme Court and the justices a little too seriously, and we put them on a pedestal, and I wanted, in some ways, to cut them down to size. Also, the story I tell about the Supreme Court is not exactly a happy one. So the tone and the snark and the irreverence and the digs are also intended to add some levity and to leave people feeling angry, but angry and empowered in a way that makes you want to fight. And then on the content, on top of the tone, there are a lot of pop culture references. So all of the chapters on different areas of law have a different pop culture motif that anchors the chapters and is meant to provide, I don't know, some analogy to better understand what the justices are doing. And that too is designed to both make the book accessible to a broader audience and also to inject some humor into the bleak story about our court. So, as far as the audience, I wanted it to be amusing and entertaining and maybe offer some information to lawyers and law students, but it is really intended for a general audience. I wanted it to be accessible to a group of people who are smart and want to understand more about the court and its relationship to politics and society.
Love that. Love that. And yeah, I have absolutely loved reading, and all the pop culture references have actually made me LOL at certain points. But So, can we talk about the title? Bad vibes is definitely a way to put it. Can you kind of explain to us what does it mean that the Supreme Court runs on conservative grievance, fringe theories, and bad vibes?
Yes, so the subtitle is definitely meant to be evocative and kind of give you some sense about what the book is about. So maybe I'll take those in reverse order. So, bad vibes, I mean, to draw a contrast with law, because people imagine the court as doing a super serious task of defining the meaning of these legal texts. And I actually think what they're often doing in at least the high profile, ideologically salient cases is they are relying on their own feelings and the feelings of those in their cultural, social, political circles, and using that as a framework for understanding the law, sometimes for overpowering the facts, and sometimes just declaring those feelings or talking points to be the law itself. And one of those big talking points is this idea of conservative grievance, where Republicans and the kind of core constituency of the Republican Party, as well as Republican political elites, imagine themselves to be the victims, either when society doesn't share their views, or when they're criticized for their views, or when a law or policy doesn't go their way. And I think that that idea is so omnipresent in the modern Republican Party. We see it everywhere. And I wanted to surface how it is also very much a part of the law that the Republican justices are creating. And I personally think conservative grievance is a little bit of a fringe theory. It is divorced from facts and reality. But I think that the justices, allegiance to a Republican Party that has leaned into minority rule has led them to embrace some fringe theories that are pretty antithetical to a liberal constitutional democracy and are also just strange, weird, and odd on their own terms.
Hi everyone, Lizzie. I'm the behind the scenes. Rachel, we can't hear you.
Okay.
We
then
can.
now I can.
Hear you now.
Now you can?
Yeah.
Yes.
The fun of virtual
Weird.
world. Thank you everyone for your patience.
Thanks, Lizzie.
Back away now.
All right. Apologies for that. So, Leah, you were just talking
It's definitely
about.
Sam Alito. He did it.
Got it. Got it. Okay. Yeah. And so the fringe theories, specifically, you talk about how not only is the court elevating conservative political views, but specifically that these aren't widely accepted, right? Like you talk about how they're ignoring the views of people who are not part of the modern Republican coalition. Can you talk about that piece just a little bit? Why is that an important theme in the book?
Yeah, so I think this is part of what differentiates the modern court from previous courts, which have always been somewhat political or even ideological. But the modern Supreme Court has become so far removed from the people, in part because of the decline of our democratic institutions, partisan gerrymandering in the House, or voter suppression and voter discrimination, the Electoral College, which allows a president to win the presidency even when he doesn't win the popular vote, Senate malapportionment. All of those things have resulted in institutions that have a say in the Supreme Court becoming further removed from the people. And so the Supreme Court is like doubly removed from the people, and it exacerbates those democratic deficits. And so for that reason, I think they have become more comfortable adopting views that are not shared by a majority of the country, and in some cases, a pretty narrow segment of the country. And the fact that they are repeatedly catering to the same small minority in the country is also concerning, because it's not like, well, different groups are occasionally winning and sometimes they lose. No, it's just kind of the same groups who are winning over and over, and the broader public keeps losing. And I think this is also partially a story of the conservative legal movement, basically creating an ecosystem where they give the justices validation and affirmation for reaching views that are held by the Republican Party, but not the broader public. Part of what the Federalist Society and other organizations like it were designed to do is to give the justices some positive feedback for doing things that they were surely going to be criticized by more mainstream outlets.
That makes sense. And I want to talk quickly about one of those particular bad vibes that you sort of start the book out with. So chapter 1 is the Kensurrection of the courts. And obviously that is a reference to the Barbie movie. Can you talk about why that is the perfect kind of pop culture analogy or reference to explain the Dobbs decision? What bad vibe are you sort of bringing out in that analogy there?
Yes, so the bad vibe at the center of the first chapter, which is about reproductive freedom and justice, is patriarchy. And the basic claim in that chapter is the backlash to Roe versus Wade is not just about abortion, it is about a discomfort with women's rights and feminism and women's ability to participate equally in civic society. And that is really what was behind the movement that gave rise to originalism and the modern Supreme Court, the overruling of Roe, and it's not going to stop with the overruling of Roe. And so, because patriarchy is, in my view, at the center of this story, I thought that the Barbie movie was a useful analog to describe what the justices are doing with our Constitution. Because in the Barbie movie, Ken goes to the real world. He gets a little taste of the patriarchy. He loves it. He decides that slaps. He comes back to Barbie land and wants to remake this feminist utopia into a patriarchy. But in order to do so, he has to ratify a new constitution, which I refer to as the Constitution. And so, what I see the Republican justices doing when they invoke things like originalism or history and tradition is they are trying to transform our Constitution into something that is a constitution because it is only concerned and focused on the views of the people who were able to participate in the drafting and ratifying of the Constitution and who were able to vote and to participate in making law in the 1700s and 1800s. And of course, that group is the group of white property owning men. And by turning over the content of our fundamental laws to that group, it has the potential to remake our Constitution in ways that will exclude and subordinate groups that haven't always been able to participate equally in politics and society.
So I love how both in this chapter where you kind of walk through the patriarchy vibes of the court, but throughout the book, how you really pull in the history of the court, the history of the political strategy, the history of what really brought us here. And so can you talk a little bit about why that's important, why Dobbs didn't happen overnight, and why the history really is something we should be looking to as we're understanding the court today?
I think the history is really important for several different reasons. One is it should give people a sense for how change happens when we're talking about institutions like the Supreme Court. The 6-3 conservative Republican supermajority didn't happen by accident. It didn't happen overnight. It happened over a period of 50 some years where the party and the movement associated with it were always willing to bear down and focus on the courts. And it didn't happen in a straight line. There were some losses along the way. And so for people who emerge from the end of the book, and I often get the question, well, what can we do? How do we change this? Part of the answer is like you need to accept focusing on smaller change, knowing that bigger change is going to take a long time. And so the history and political context there is useful for underscoring that part of the story. I also think that the political history and social history is useful to drawing out what the law is doing and what the justices are getting at, because sometimes you can see their reasoning is really just laundering and recycling, talking points that they tried to use against the Voting Rights Act, for example, or against the Equal Rights Amendment, for example. And the fact that you can see the same reasoning and ideas and language in the law is another way of showing the ways in which politics influences the law and how the justices are reasoning.
And speaking of how politics influences the justice's reasoning, so you mentioned briefly originalism. Can you just explain for our audience the concept of originalism, how it shows that sometimes these terms are not what they sound, and how these terms can be weaponized?
Yes, so originalism is the idea that you should interpret the Constitution by asking what a provision in the Constitution meant when it was originally adopted and ratified. So that approach is always going to turn decision makers' attention back to a time when the country was less democratic. Again, many of the provisions in the Constitution were added in the 1700s and 1800s when racial minorities, women, and other groups were not allowed to vote, were not allowed to be themselves in public. So, as a methodology, it lends itself to turning back certain advances in civil rights. And that was really what it was initially offered to do. So, the first articulations of originalism actually happened in the wake of Brown versus Board of Education, the decision that invalidated segregation in public schools. And segregationists argued that decision was inconsistent with the original intent of the people who created the 14th Amendment and, of course, who practiced segregated public education. And then it really takes off and picks up steam in the 1970s and 80s as the Republican Party kind of co-opts the Federalist Society's views about the law as an effort to achieve the social issues and social policies of the Republican Party that had leaned into the backlash to feminism. So during the Reagan administration, his attorney general gets up and says to the entire American Bar Association, a jurisprudence of original intentions is a way to turn back the radical civil libertarianism and egalitarianism of the Warren Court. They're talking about taking away equality and civil rights from groups that didn't always enjoy it. And you can see, I think, the similarities in originalism and its approach to the Constitution in the slogan of the Republican Party. You know, make America great again kind of promises the restoration of some past, some prior time when America was supposedly great. And originalism is also a promise to restore things to the way that they were.
You mentioned the way that the Supreme Court has been really chipping away at the Voting Rights Act, and you talk about specifically. I'll just give a quick quote from your book that the right believes, quote, that they are entitled to write rules that secure them political power, even when they may not have the votes, and that is antithetical to democracy itself. So just specifically talking about kind of the chipping away at the Voting Rights Act, just considering the trajectory of the Supreme Court's rulings, what do you see as sort of the potential long-term consequences for the future of equitable access to the ballot box?
I mean, I think what they are mounting is an attack on multiracial democracy because the through line is, any set of rules that creates, for example, a majority white district or Republicans having political power, those rules are fine and constitutional. But basically anything else raises hackles for them. And again, like you can see in their reasoning, both the entitlement to political power as well as at best, apathy to democracy. So, in the oral arguments over the Voting Rights Act, when the court was considering whether to invalidate the pre-clearance process, the part of the Voting Rights Act that required certain states with especially bad histories of racial discrimination to get permission from the federal government before changing their voting laws or policies, you had Justice Scalia complaining about how the Voting Rights Act was a quote racial entitlement because there were certain districts that were Black districts by law now. Well, why is that a problem? But it's not a problem for districts to be majority white. And you had echoes of these same ideas, in the court's earlier voting rights decisions as well. Also, during the argument, Justice Scalia was complaining about how Republican politicians couldn't vote against the Voting Rights Act because if they did so, they were, quote, going to lose. The idea that if a politician does something that's unpopular and then loses, that is democracy. And that seemed to be a problem for Justice Scalia. So it's that combination of entitlement to power with, that entitlement basically transcends and supersedes democracy itself that I think you can see in many of the challenges to voting rights, both as a constitutional matter as well as, the Voting Rights Act itself.
So given that trajectory and this vibe that has existed, do you see any potential avenues for the progressive movement to counteract this trend in this sort of opposition to democracy?
Yeah, I mean, I think this is one of the issues in which the court is definitely embracing a fringe theory. The vast majority, a supermajority of the American public doesn't think politicians should be able to choose their voters or lock themselves into political power even when they lack majority support. People don't like partisan gerrymandering. People don't like not being allowed to vote. So I think this is one of those issues where focusing on statewide protections, whether it be ballot initiatives, whether it be state Supreme Court races where democracy is on the ballot, that can be a powerful tool for advancing change. And of course, that kind of change will build on itself over time to hopefully allow us, to one day have a Supreme Court that is not hostile to democracy and multiracial democracy. But I think at a minimum, this is an issue where public opinion is on the side of democracy and voting. So trying to fight those issues and secure protections through state voting rights act or other constitutional protections and state constitutions, I think all of that can be helpful.
And do you think that this current approach that the court has had, or historical approach, is affecting public confidence in the judiciary? And how do we navigate that? Do you think the damage is reversible? How do we navigate giving people awareness of these issues, but also maintaining the public confidence in the judiciary?
I mean, I think the court is definitely at fault for a lot of the drop in its public approval ratings. It's no accident that after they overruled Roe versus Wade, their approval ratings went down the toilet, as people were confronted with stories of women being denied health care and having their lives, health, safety, reproductive health jeopardized because of the abortion restrictions that the Supreme Court had allowed to go into effect. Do I think that part of the, lack of faith in the court is attributable to their decisions on the law of democracy? Yes, because it's not just voting rights and democracy where I think the court is going against public opinion. It's also on issues like money and politics. Again, the vast majority of the country doesn't think a few super rich dudes should be able to outspend by grotesque amounts everyone else. So that too is an issue where the court has taken what I view as a fringe theory because it is so not widely shared and in fact widely opposed by broad swaths of the American public. So I think the fact that the court has repeatedly done that and including on issues of democracy is absolutely partially the explanation for the drop in the court's approval ratings. And that has created a really, I think, precarious situation right now because in a world where you have an executive branch that is uncertain about whether they are going to comply with court orders, you really need public buy-in for the Supreme Court and courts' ability to enforce the law, especially federal statutes that constrain the executive branch. So I think the court is, partially responsible for the real precarious situation that we now find ourselves in.
Well, I want to quickly turn to a quote that I
Rachel, sorry, we're having audio issues again. Thank you, everyone, for your patience.
Okay, can you hear me now?
So I can.
It's so strange. Can you
You can't have a virtual event without something like this. I can hear you for now. I will let you know again if we can't.
Okay. Thanks, Lizzie. Apologies, folks. So I was turning to a quote that I loved. So you said in the book, quote, "Things that you might hear or read about the court can gloss over the court's messiness with some Instagram level filters." So I think you were talking about how it can be difficult for the public to really understand the full implications of an opinion or to just understand beyond, who won and who lost. How does that contribute to a dangerous perception that the court is moderate or apolitical? And how do we combat that?
Yeah, so I think too often the media just focuses on, well, what kind of change did the court make in this case? And the change from one case to another might not be that significant, but the changes across, let's say, 5 cases over the last 5 years are extraordinary. Just to take one example, the religion and education cases, 6 years ago, the Supreme Court was saying, well, states can't deny funding to religious schools for playground pavement. And that seemed unobjectionable, right? The funding wasn't being used for religious instruction or to teach religious doctrine as truth. But then over time, the court started saying, well, also you can't deny tax write-offs, you can't deny public funds to schools that are religious in nature. And now all of a sudden the court is at a point where they might say, actually, states are required to create religious public charter schools. Again, schools that teach religious doctrine as truth. So the change from any one case to another might not seem significant, but the radical transformation in the role of religion in public education is extraordinary. And I think that too often the stories just about one case miss that broader context, and they won't discuss the political movement that has been laser focused on trying to achieve that for the last 5 decades, if not more. And then I also think the media tries to look for seemingly objective ways of describing the court, like statistics, where they will point out, well, actually, most Supreme Court decisions are unanimous. And that's true, but it doesn't obscure the fact that the non unanimous decisions are the ones that are making radical changes in our society or our government. And so I think that the media's commitment to a certain kind of journalism, as well as just the very real constraints on, they only have 1,000 words for a lot of these stories. They need to get instant analysis of an opinion. They might not have been immersed in absolutely every development in the case law for the last 50 years. All of that kind of produces coverage of the court that I think does not capture what the court is doing.
That makes sense. And so, speaking of not fully capturing or understanding what the court is doing, you talk in the book about how you're going to help us to read opinions for filth. And in the coming weeks, we're going to see several decisions handed down by the Supreme Court. What does it mean to read for filth? How do we think about looking at these opinions as they come down and read them for filth ourselves?
So, Read for Filth, I'm a big RuPaul's Drag Race fan. So, this is a reference to the reading challenge in Drag Race, where all of the contestants are invited to read each other, which basically means, mock each other and drag them for filth. So, that is the use of reading that I am invoking here. As to how to get ready to do the reading challenge for Supreme Court opinions over the next month, I think it is realistically trying to figure out, like, what are sources of information and what are media or advocacy organizations that I can trust to give me a fuller picture. And some of that you will probably want instant analysis. But realistically, in order to get the full picture, you should also figure out, okay, well, what are, I don't know, some organizations that are going to do longer form analysis of the Supreme Court term once it ends? Or what are some organizations that are going to put out some white papers or briefs on opinions, let's say like the week or like a few weeks after the fact, so that I can make sure I'm not missing anything? And, we are all busy. We don't all have the time to process all of this information. So I think figuring out like an informational network that you can be part of, a group of friends who one person might be really interested in voting rights, and there's a big voting rights case that we are waiting on. Other people might be interested in LGBT equality. There are important LGBT equality cases that the court is hearing. So figuring out how you can kind of transmit information within your community and your networks and what sources to draw upon are, I think, probably the best ways to get ready for decision season.
Love that. And I'll just put in a plug for AFJ, and we have many sources to kind of give you that information. Is there any particular opinion from this term that you expect will absolutely need to be read for filth this next month?
Mahmoud versus Taylor, the case about school districts' inclusion of LGBTQ inclusive reading material in their classrooms. So, in this case, a group of parents challenged a Maryland school district's decision to include storybooks with LGBT characters in them, arguing that these storybooks violated their religious beliefs and that they had to have a right to opt their child out of any instruction with the storybooks. I think that could just be hugely destructive and unworkable in a public school system where realistically teachers in schools cannot create individualized curriculum to every single student or any student with parents who might have objections. And so what that is going to mean is it is going to force classrooms to basically create curriculum that no parents will have any objection to. And I think that's going to be a real problem for public education. And, the idea that the storybooks in that case in particular were objectionable were just ludicrous. Like hearing the justices' takes on those opinions or those books was really wild. Justice Alito read this book, Uncle Bobby's Wedding, that was just about a young girl who was concerned that her favorite uncle would have less time to spend with her because he was getting married, as a story about maybe a young girl having religious objections to marriage equality and then her mother telling her, no, you can't object to marriage equality. So just seeing them again hamstring public schools and basically force school districts to exclude LGBT individuals from the classroom based on these overwrought dramatic readings of these children's books, that is definitely something that is going to have to be read for filth.
Rachel, we're back to
We're
no
back.
audio. Oh, no, you're back. Every
I'm
time I
back.
pop up, it's back.
Maybe
Yeah,
you're just
so
the good luck charm, Lizzie. Okay, apologies, folks.
sorry, everyone.
All right. So chapter 2 of your book, called You Can't Sit With Us, you really discuss the ways in which the Supreme Court has shaped the movement for civil rights for the LGBTQ plus community. Just going back and talking about the Mahmoud case, the Scrutiny case, can you talk about some of that history and how we're going to see some of that, those bad vibes play out in these decisions?
Yeah, so the bad vibes in this chapter are really twofold. And I think in some ways they're, two sides of the same coin, but I think identifying them both is important. One is this idea that actually discrimination against the LGBT community isn't discrimination at all. And that is paired with this notion that, but equality for LGBT individuals, that is discrimination against the religious and social conservatives who object to LGBT equality. And I think you can see that in full force in the cases we are waiting for decisions in. So United States versus Scrutiny, that's a challenge to a ban on gender affirming care for minors. And the question is that a form of unconstitutional sex discrimination, or a form of animus-driven discrimination against the transgender community that should lead a court to subject those kinds of laws to careful scrutiny or heightened scrutiny? Based on the argument, my guess is the Supreme Court is going to say no. So bans on gender-affirming care are not a kind of discrimination that triggers meaningful judicial review. At the same time, in Mahmoud versus Taylor, they are going to say that the inclusion of LGBT storybooks, that is an affront and a kind of discrimination against religious and social conservatives who object to LGBT equality, or in some cases, the mere existence of LGBT individuals, particularly transgender individuals. So I think that those two ideas are very much the vibes that are at work in the court's cases on LGBT equality. And they were also the vibes, as you suggest, in the movement that the Republican Party capitalized on that was hostile to LGBT equality. So in the book, I talk about the origins of Anita Bryant, who was kind of like one of the public figures who was opposed to LGBT equality, and how she insisted that her campaign to repeal all of these ordinances prohibiting discrimination on the basis of sexual orientation was not driven by hatred or animosity, but out of love. Like, the fact that they have sincere views means they can't possibly be engaged in discrimination. And at the same time, she accused the quote, homosexuals of the country and political officials of being engaged in a campaign of religious bigotry. So she wasn't engaged in the discrimination. It was everybody else. So I think you can see those vibes in the political movement, the social movement, and now in the opinions.
All right. So, as you acknowledge in the book, all of this is quite bleak. Leah, what do you think that we, the public, what can we do about it? For our readers, for our viewers who are concerned about the direction of the Supreme Court, do you think change is possible? What do you think we can do to make change happen?
I do think change is possible, and it's going to start with public information and education. I think one of the real problems and shortcomings is, lack of civic education, lack of information on the part of voters, and so I think coming up with ways to counteract that is an important first step to facilitating any kind of political change on any level. If you look at the retrospectives on the 2024 election, in some voter surveys, you had absolutely stunning claims like voters held Joe Biden responsible for the overruling of Roe versus Wade because he was in office when that happened. So communicating to people who's on the court, who appointed them, who's making decisions, that has to be an important part of the information and education. Similarly, voters were holding Joe Biden at fault and responsible for not fulfilling his promise to do student debt relief. Well, who prevented him from doing student debt relief? It was 6 Republican justices on the Supreme Court. So providing people with information about government and civics and what the Supreme Court is doing has to be a first step to creating any kind of change. And I do think that that makes change possible. I live in Michigan. We used to have one of the most conservative state Supreme Courts in the country. We now have a 6-1 progressive Democratic majority on the Supreme Court. So change is possible if you invest in the kind of information, organization, and education, and then getting people to vote based on that information, organizing, and education. So it's going to take time, particularly at the federal level, but I do think it's possible. Rachel is now silent.
Yes. Rachel, we can't hear you at the moment. Okay, you figure that out. I'm going to pop to an audience question while Rachel works
Perfect.
on her. Oh, you are back though.
All right. Should I go or you go, Lizzie?
Well, I will leave it to you, the professional. And Leah, hopefully this has been the most exciting virtual event thus far on the book tour.
As a podcaster, I'm very familiar with tech hiccups. So,
well, I'll ask one last question, and then maybe Lizzie, you can pop in for some of the audience questions just because of my audio. But so just you talked about this a little bit before also, but can you talk to us about why we should also be focusing on state Supreme Courts and not just the federal courts?
yeah, so I think state Supreme Courts are useful to focus on, in part because a lot of law is state law, and state Supreme Courts are going to have the final say over those matters, absent some federal constitutional challenge to state law. Second is state Supreme Courts can sometimes fill in the gaps and stem some of the damage from disastrous United States Supreme Court rulings. So, in the wake of the court overruling Roe versus Wade, for example, in Michigan, we tried to get and successfully got a ballot initiative to protect reproductive freedom onto the ballot. But Republicans tried to block that ballot initiative from actually appearing on the ballot on the basis that some of the petitions had been squished together in typeface. So just like a real ticky-tack kind of foul. And it's because, we have a sensible state Supreme Court that insisted, no, the voters get to vote on this, that we now have state constitutional protections for reproductive freedom. So state Supreme Courts can play an important role in safeguarding rights when the United States Supreme Court isn't able to do so. And also, it's just, I think, easier to change state Supreme Courts more quickly than it is to change courts at the federal level. So I think focusing on that as, smaller steps along the way to changing the federal system can be a way of seeing some returns in the shorter term.
All right, I'm back, everyone, just to help, just in case. And I am in a t-shirt,
Take it away, Lizzie.
In honor of Leah, I'm wearing my Eras t-shirt because we're big Swifties.
Love it.
So we had a few audience questions. I want to go to the one I am most excited about, and then we can do the more legal ones. That's because I'm more of a pop culture girly than I am no lawyer. But one of the questions was, what pop culture references did you really want to include, but you just couldn't find the right analog for them?
Yeah, there were a few that didn't actually end up making their way into the book. One was I wanted to do some things from the Clueless movie. That was another possibility for the chapter on wealth and economic inequality, but ended up going with Arrested Development instead. Similarly, Succession also almost made it in there, similar chapter, but had to go with just one. There are so many spoofs you can make of this court. Those are just two that come to mind immediately.
Big Clueless fan, also loved Succession, but loved every pop culture. The one I've not watched Game of Thrones. I know I always get a flack for that, but it was still help make it easy to understand. All right, some more legally questions. So referencing yesterday's cert denial in Apache Stronghold versus U.S., can you explain and go into Justice Gorsuch as a defender of tribal rights and how it fits or doesn't fit with the rest of his record?
Yeah, so I think all of the Trump appointees, at least, have an issue or issues in which they are a little bit different than the other Trump appointees. And for Neil Gorsuch, that issue is federal Indian law and Native American affairs. As to why that is, hard to say. Some speculate that it's because of his time out west and familiarity with, Native nations and tribal law that has led him to be more solicitous of tribal autonomy and Native peoples and Native nations rights. So the latest, statement in the cert denial is just an example of this. I think somewhat famously, he wrote the majority opinion in McGirt versus Oklahoma that had recognized that, a major reservation was still intact and had not been either ended or minimized by the state's actions in trying to challenge tribal authority over time. So I don't know if that totally answers the question, but I think you can also think of some of his solicitude for tribal rights and Native nations as a little simpatico with his more libertarian instincts, again, at least relative to Justices Barrett and Kavanaugh.
Thank you for that. And can you hear me?
Yes.
All right, I'm going to jump in. Great. Okay, I'll jump in with another audience question. Leah, do you think the lawlessness of this conservative-leaning court is why the justices ruled the way they did in the presidential immunity case, Trump versus United States?
Yeah, so I think that is a great example of how the justices are high on their own Federalist Society supply and fringe theories, and also how their worldview of conservative grievance really influences how they see the decisions. I think that was a case where most Supreme Court commentators, watchers, analysts really did not think the court was going to embrace any kind of immunity that Donald Trump was asking for. And instead, what happened is the court basically adopted an even broader version of immunity than what Trump asked for. So why do I think that is emblematic of, the lawlessness that I described? One reason is because in some ways, the most concerning aspects of that decision we're not just saying, presidents are entitled to immunity from criminal prosecutions, but the portions of the opinion that purported to declare here are areas where the president's powers are exclusive, such that not only can they not be subject to criminal laws, maybe they can't even be subject to civil laws as well that could be enforced in civil suits. And in order to arrive at, here are the areas where the president's powers are exclusive, it was pretty apparent that the court was relying on this unitary executive theory, which I had alluded to before, this idea that the Constitution vests all the executive power in the president and the president alone, and therefore requires the president to have pretty substantial powers to control everyone in the executive branch. So seeing them lean all in on the unitary executive theory in this case involving a president who had tried to overturn the results of a legitimate election, interfere with a peaceful transition of power, was, to my mind, a great example of how they are very susceptible and open to fringe theories that obscure, the deeper picture of what is happening in a particular case. I also think that decision reflects some possibility that they viewed some of the prosecutions and some of the litigation against Donald Trump as almost evidence, not of Donald Trump's danger to the constitutional republic, but of Trump derangement syndrome. The idea that litigants, political appointees, they were so obsessed with getting Donald Trump and anti-Trump that was what was driving some of these cases. And that was the risk that the court needed to address, rather than the risk that a president who, freed from the prospect of any individual liability, might refuse to leave office and try to interfere with the peaceful transition of power. So yes, I think that the immunity decision absolutely reflected the kind of lawlessness that I talk about. And even the timing of the decision, I think, reflects the lawlessness, because even before they issued that decision, they slow walked the immunity appeal in a way that all but ensured, Trump was never going to face charges on election interference before people went to vote in the 2024 presidential election. And again, in a world in which, January 6th, the idea of pardoning the January 6th rioters, that's not popular. That is not something that a majority of the American public supports. So subjecting him to a trial for his participation in the Stop the Steal movement that resulted in the January 6th riot was something that could have provided the American public with a lot of meaningful information. So the Supreme Court ensured that wasn't going to happen. They turned away Jack Smith's early request to hear the case in December. Then when they finally agreed to hear the case in February, they scheduled it for 2 months later at the very end of the term, and then didn't release the opinion until July, even though they ordinarily finish a Supreme Court term by the end of June. So all of that delay, in addition to the substance of the decision, I think was just a huge handout and gift to Trump's reelection.
Definitely. We have two more audience questions. So another is on another recent action of the court. So allowing for the removal for now of the National Labor Relations Board and the Merit Standards Protection Board members. So defying the letter of the law, breaking with 90 years of precedent. What does this demonstrate to you? The audience member asked, does it show a dangerous authoritarian break? How do you foresee this action of the court?
Yeah, so I don't think it shows anything good. There are several pretty bad aspects to the decision. One is it all but confirms that the Republican appointees are not having any second thoughts about their immunity decision. If they looked around at the world and thought, wow, maybe we emboldened and enabled Donald Trump's excessive assertions of executive power, they certainly didn't show it when they allowed him to fire federal officials in violation of federal law. They also allowed him to do so by thumbing his nose at the Supreme Court's 90-year-old precedent in Humphrey's executor. So not only were they willing to give him, a pass for violating federal statutes, they were also willing to acquiesce in his effectively overturning of Humphrey's executor, the decision that had laid the foundation for independent agencies. You add to that just the utter lawlessness of their reasoning itself, where they just declare, well, of course, all executive power is vested in the president, and therefore he has to have the power to remove anyone exercising considerable executive authority. That's the unitary executive theory I was just talking about. But then after they announced this new made up theory that, again, the conservative legal movement has been pushing for 40 years, it turns out when you unleash this theory into the wild, it has pretty potentially catastrophic consequences, because it could allow the president to remove members of the Federal Reserve Board and implode the economy. So what do? They have to announce a new made up ad hoc exception that reflects nothing more than the court's functional concerns that allowing the president to remove the head of the Fed would be real bad. And so I think that just shows the extent to which they are second guessing Congress's decisions, allowing themselves to invent new theories and make it up as they go, and how that reflects, again, the ideas that have been being pushed by the Republican Party and conservative legal movement while trying to insulate that party and that movement from the consequences of their views.
And before I turn it to Rachel for the last audience question, if you want more insight on Humphrey's executor, I recommend going to listen to this week's episode of Strict Scrutiny, where there's a conversation on it. So just a plug.
Thanks, Lizzie. So our last audience question for you, Leah, can you talk a little bit about the significance of the shadow docket?
Yeah, so the shadow docket refers to how and where and when the Supreme Court issues orders on sometimes an emergency basis, but always, without full briefing or oral argument. And so sometimes those decisions are really anodyne, whether to grant the Solicitor General's request to participate in an oral argument or whether to give permission to file an amicus brief, for example. Other times they are much more consequential. And in particular, as Professor Steve Vladeck has documented, he has a book, The Shadow Docket, because he's documented the rise of the first Trump administration really saw an escalation in the use of the shadow docket as the Trump administration repeatedly ran to the Supreme Court, asking that court to get them out of lower court rulings that had gone against them. And the Supreme Court seemed to signal they were totally fine with this since they did not turn away the Solicitor General's requests. And I think that only invited more of them. And that has gotten us to this position where there are now so many emergency requests at the Supreme Court from the Trump administration and others from unfavorable rulings. And again, because the Supreme Court doesn't seem to be holding it against the Trump administration that they're asking for this all the time, they're certainly not creating a deterrent, against making those kinds of requests.
All right. Well, Leah, we are so grateful for your time with us today, your wisdom, and of course, the levity, but also seriousness that you bring to this very important conversation. Do you have any final thoughts for our audience? Any additional things you'd like to say about the book? Please jump in.
So I guess I would say I had fun writing the book. In some ways, this book has been in the works ever since I clerked at the Supreme Court almost 15 years ago when they heard the constitutional challenge to the Affordable Care Act litigation. And I wanted it to feel like a book that simulated a conversation between you and your best friends who were just talking smack about some of the absolute worst people that you know. And so I wanted this book to be empowering. I wanted it to agitate people in a way that got them ready to fight. I hope people enjoy reading it. Again, I had fun writing it. So please consider getting the book, maybe stocking up your local free library or your public library with the book so other people who might not be able to buy it are able to read it. And yeah, the book is Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. I have it printed on my shirt and also right here.
And I've got my copy here. Thank you again, Leah, for this great conversation. Can you hear me?
A little, not really. We almost
All right,
made it to
now?
the end.
Hello?
Yes, I
Yes.
don't know. Maybe
It's interesting. Okay.
Lizzie has to come back on screen in order to fix
Clearly.
your microphone.
Clearly, my microphone only loves Lizzie. Okay. You can still
I'll
hear me
stay on
now?
to the end.
Yes.
Yes.
All right. All right. Well, Leah, thank you again for this really important discussion. I just have to say what I find so helpful, fascinating, great about the book and the discussions that it sparks is just how you make these topics accessible. You make it fun without diminishing the importance of the topic. And you remind us that even though our courts are fragile, and even though things look quite bleak, that really we can rise up together to fight for the justice that we all deserve. So I love the approach in Lawless, also love the approach in your podcast, just making the complexity of the court more accessible to wider audiences. I really think this is how we empower more people to join this fight. So if you want to learn more and get engaged to our audience, please pick up your copy of Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes, with many important Supreme Court decisions expected to come down in the next few weeks. Also, subscribe to Leah's podcast, Strict Scrutiny, where she and her co-hosts will be debriefing these decisions. We also hope that you will follow Alliance for Justice on social media to stay up to date on future events like this. We really appreciate your participation today and look forward to your continued engagement in our future discussions. Thanks for tuning in. We can't wait to see you next time.